One of the most common documents which people come to their lawyers to have prepared or want more information about is known as the living will. Now, the phrase living will generally became part of our common language in about the 1980s when the case of Nancy Cruzan began in Missouri. In January 1983, 26-year-old Nancy Cruzan lost control of her car while coming home from work, a terrible accident, and Nancy Cruzan was left severely brain damaged and in an irreversible coma. The Cruzan family asked the hospital to remove the tubes that were keeping Nancy alive, but the hospital refused. So the Cruzan family had to sue the state of Missouri, and eventually the case made it to the United States Supreme Court. In a close 5-4 decision, the Supreme Court recognized the right to self-determination and the right to die. The Supreme Court then sent the case back to the Missouri trial court to see whether there was clear and convincing evidence of Nancy Cruzan's wishes with respect to her right to die. Now, after hearing further testimony from Nancy Cruzan's co-workers on this issue, the Missouri court did find clear and convincing evidence of Nancy Cruzan's wishes, told the hospital to remove the tubes that were keeping Nancy alive, and Nancy Cruzan eventually died about 2 weeks after the tubes were removed. She essentially starved to death, and in December 1990, 7 years after her horrible accident, Nancy Cruzan died. So the Supreme Court recognized there was such a thing as the right to die, and in New York there are several cases, most importantly 1988, the O'Connor case, wherein the right to self-determination with respect to medical procedures is clearly a long-standing part of New York law, and the Supreme Court followed this up later on, a few years later, in the Cruzan decision. So the point here is that the right to die must be evidenced by clear and convincing evidence. And so the living will is a document in writing which is intended to satisfy this clear and convincing standard. One of the problems, though, with respect to writing down your wishes with respect to end-of-life decisions in a living will is that it's impossible to predict how or why or under what circumstances this right to die may become an issue in any particular person's life. And in fact, in 2004, the Hastings Center, a well-respected bioethics institute in Garrison, New York, found that the living will is virtually a failure. And primarily for two reasons. First of all, people often complete a living will and then put that in their desk drawer, and nobody knows the living will actually exists. But number two, it's often hard to apply a person's wishes as stated in the living will when the situation actually arises, because there is so much room for disagreement and uncertainty in this area, particularly when there are so many overlapping legal, ethical, moral, and religious opinions about this subject. Fortunately, in 1991, the New York State Legislature passed a law which provides a great deal more certainty for New York residents. The legal document in New York is known as the healthcare proxy. Now, a proxy is just a word which means someone acting on another person's behalf. For example, many people own corporate stock, and every year you might get in the mail from the board of directors a proxy. And the board of directors is asking you to sign this proxy so that they may vote your shares on various issues. You're giving the board of directors proxy with respect to corporate decisions. The healthcare proxy is just that. You're naming another person to act on your behalf with respect to healthcare decisions. Healthcare proxy, someone acting on your behalf with respect to healthcare decisions. Now, New York's statute is much better than a living will because it provides a great deal more certainty with respect to healthcare decisions and medical decisions, because a proxy, don't forget, is someone acting as you would act. And so if a proxy is making medical decisions, that's just as if you are making those medical decisions, and so there's really no room for debate as to what you might want or would not want, because in effect the proxy is stepping into your shoes to make those decisions and carry out your rights. And since among your rights are the right to die, or the right to refuse medical treatment, or the right to direct one medical treatment over another, the healthcare proxy is a much more important law that we have to protect New York residents. But it's important to understand a couple of things, and that is that your healthcare proxy is acting on your behalf not only for end-of-life decisions, but more importantly with respect to medical treatments, surgeries, the administration of medication, for example, that might actually save your life. It's also important to understand that your proxy has authority to act only when you cannot do so, so that if you can continue to communicate with the doctors and communicate with the nurses with respect to what your wishes are regarding medical treatments, then the healthcare proxy is meaningless. The proxy cannot override your decisions. And it's also important to understand that the healthcare proxy cannot ask the doctors to remove life-sustaining treatment when there's a chance that you'd recover from the injury. Why? Because that would be suicide, or at least assisted suicide, and those are illegal in New York. And since the proxy is acting for you and carrying out your rights, and you don't have the right to commit a crime such as suicide, then neither can your proxy. Now, despite having the availability of naming a healthcare proxy and completing this healthcare proxy form, many New York residents nevertheless insist on making a living will. And I think there are a couple of reasons for that. Most importantly, I think it's because New York residents just don't know about the existence of the healthcare proxy law and that it's available for New York residents. Also, in most other states, this type of advanced directive, as a healthcare proxy is known, an advanced directive is in fact known by the term living will, or a phrase that includes the term living will, so that when this subject is discussed on television or in newspaper and magazine articles, for example, the phrase living will is often used because that is in fact the term which applies in most of the states other than New York. Now, most New York attorneys would try to convince their clients not to complete a living will, and instead only to complete the healthcare proxy, because the healthcare proxy is the official form that we have in New York for that purpose. And many attorneys consider that a living will can only add some uncertainty to this area and cause confusion where there doesn't need to be confusion, and that a living will is unnecessary. But there are a great many attorneys that do encourage their clients to complete a living will on the theory that it will help your healthcare proxy and perhaps your family to understand better what your views are with respect to end-of-life decisions. So on the website, I have some samples of living wills and one or two healthcare proxy forms. The healthcare proxy is a document that you don't need an attorney to complete. the New York State Department of Health has an excellent healthcare proxy form that's easy to complete, very easy to understand, and more importantly, the hospitals and doctors in New York are very familiar with the New York State Department of Health healthcare proxy form. So I encourage you to download that form, take a look at it. You need 2 witnesses. Doesn't need to be notarized, but the healthcare proxy is one of the most important documents that any person can have. So once again, thanks for spending some time at rickbryan.com, and I hope I've given you some useful information.